So let me ask you, we can go to the Constitution, let's say the Bill of Rights to narrow the discussion, and read about our explicit rights. Religious freedom, our right not to be unreasonably searched or seized, freedom of speech, they're right there. That's why they call them explicit. But the court has ruled we have a bunch of unenumerated rights. Am I correct?
The court has determined there are certain personal rights related to individual autonomy that are implicit in the concept of ordered liberty or deeply rooted in our nation's history or tradition.
But they're unenumerated.
Day one of the Supreme Court confirmation hearings was anything but ordinary. Senator Kennedy came out swinging, grilling President Biden's nominee in a way that left no room for easy answers. This was more than just political theater. It was a crash course in how the next justice could shape the future of the country. Welcome to Hot News Today. Let's break it down.
You don't support efforts to delegitimize the United States Supreme Court, do you?
Senator, I have nothing but esteem for the United States Supreme Court, for my hopefully future colleagues on the court, and the work that the court does.
Can we agree that the calls to pack the court delegitimize the court?
Senator, it would not be appropriate for me, in my view, to comment on calls to pack the court, as you say, to increase the number, to do any structural changes. Those are policy determinations for Congress. What the consequences of those are policy considerations for Congress. I'm just looking forward to working with the brilliant people who are there at whatever size Congress decides if I'm confirmed.
Well, the calls to pack the court don't legitimize the court, do they?
Well, Senator, I think that would be for you to decide.
First up, Kennedy wasted no time diving into the court-packing debate. He warned that expanding the Supreme Court could shatter its legitimacy. But the nominee played it cool, refusing to take a side and reminding everyone that's Congress's job, not the court's. Kennedy kept pressing, but the nominee stayed on script. Neutrality above all.
I'm asking your opinion.
Respectfully, Senator, I'm not in a position to give my opinion on issues that are policy issues concerning the court, and not something that a judge would have to consider or should consider, in my view.
Yeah, but you're a citizen.
Oh, I am.
And as best I can tell, a very good one. I don't understand why you won't weigh in on this issue. Tell me why you won't weigh in on this issue.
Senator, I feel so strongly about ensuring that judges remain out of political debates. And this is something that is being debated. It is something that other nominees, Justice Barrett was asked about the same sort of thing and also declined to give her opinion. And I think that was the right way to handle this particular issue.
So you think Judge Barrett was right to dodge the question?
I think that each judge has to make a determination when asked about whether they would like to speak to issues. And I know that I'm not comfortable, in part because I'm so committed to making sure that there's confidence in me in terms of public confidence and my ability to stay in my lane, my ability to not speak to contentious political issues.
Next, the conversation turned to precedent. Kennedy wanted to know, is it normal for the Supreme Court to overturn its own old decisions? The nominee said yes, it happens, though only after careful consideration.
So you'd be okay if it was 28?
If that's Congress's determination, yes. Congress makes political decisions like that.
A couple of my colleagues ask you about the Supreme Court overturning precedent. Now, it doesn't happen every other Thursday, but it's not what's the word I'm searching for, Judge? It's not extraordinary that the Supreme Court overturns precedent, is it? I mean, it happens. I won't say a lot, but it's not once every 50 years. Am I correct?
You're correct that it's more frequent than once every 50 years, for sure. Yes.
And so it happens.
Yes.
And you talked earlier briefly about the different factors that the court considers
Yes.
in deciding. Give me a couple of those. Hit that another lick for me and just give me a couple.
Whether the decision is egregiously wrong, whether there's been reliance on the decision that is being revisited, whether the decision is workable or unworkable, the one that they're looking at, whether the facts are new facts have come to light, or the facts have the circumstances are such that there's now a new understanding of the prior facts, and whether the case law in the area has shifted.
And in fact, those are the factors that the Supreme Court listed 3 years ago in Janus, are they not?
Those are the factors. I don't have the Janus opinion in front of me, but those are the factors that the court uses.
Kennedy pushed further. Should the age of a decision matter, especially if science or society moves forward? The nominee wouldn't bite, steering clear of specifics. Then came the hot topic of judicial restraint. Kennedy pressed the nominee on what it means to stay in their lane. The nominee insisted judges should interpret laws, not make them. Kennedy seemed to like that answer, but wasn't done yet.
The older decision is more likely to be overturned, you think, based on your experience?
Oh, I don't know that I could make that prediction. I'm just saying that one of the factors, the reliance factor, the age of the opinion and how long people have been relying on it,
Yes, ma'am.
can be relevant to, it is one of the factors that the court considers.
Right. Okay. Let me jump gears here. I took some notes. You talked earlier about how you decide cases. I'm going to kind of summarize this. You said you clear your mind of any bias. You read everything. You read the briefs and the record, and then you apply the law. That's your methodology. You said you're not an activist judge. You said, am I right?
Yes,
You said judges are not politicians,
that is true.
and judges should stay in their lane.
Yes, sir.
Tell me again what you mean by stay in your lane.
What I mean is that in our system of government under the Constitution, we have a separation of powers, and each branch has their own sphere of responsibility. To say stay in your lane is the shorthand that I'm using for indicating that judges should not be policymakers, that those responsibilities are left to the elected branches, and that judges are to interpret the law, not make the law. And I use it to refer to the part of my methodology that is mindful of the constraints on judicial authority.
Okay.
He wanted to know if judges are risking overreach when they recognize new rights, like those not spelled out in the Constitution. Once again, the nominee dodged, citing the need for neutrality. The sharpest moment? Kennedy grilled the nominee about the 9th Amendment. Can judges just invent new rights if they have 5 votes? The nominee referenced precedent, but Kennedy pushed back, arguing that the founders gave us a way to add rights through amendments, not the bench. Rapid fire, Kennedy asked. When does life begin? The nominee said personal beliefs stay personal. When does equal protection start? The nominee didn't know the legal answer. Kennedy wrapped up by probing state versus federal protections. The nominee agreed, states can go further, as long as they don't clash with federal law. These exchanges weren't just about one nominee, they were about the soul of the Supreme Court itself. Kennedy pushed hard, the nominee held the line, and the real battles are just beginning. If you found this eye-opening, hit like, share, and subscribe for more breakdowns from Hot News Today.